Ultimately, it's going to cost you a little bit of money, but you'll make more money because you're going to be operating your business in a less risky way. You'll have less exposure and less problems that are going to cost you money to fix.
Welcome to the Rental Property Owner and Real Estate Investor Podcast, brought to you by the Rental Property Owner Association, providing benefits and services to real estate investors and rental property owners for over 45 years. With your host, Brian Hamrick from Hamrick Investment Group.
Hello and welcome to episode 12. For every rental property owner and investor, there comes a time when you will need expert legal advice. Whether you're putting together a contract or a purchase agreement, forming an LLC, or dealing with a slip and fall at one of your rentals, having an attorney on your team is essential to protecting your interests and investments. Today, I sit down to talk with David Hill. He's one of the RPOA's team members, and he's also a real estate attorney for Christ Enderle here in Grand Rapids. David and I will discuss a wide range of topics. Now, I know that everyone's legal situation is different, so the opinions that you hear in this podcast today may or may not apply to you. However, in this conversation, David will share enough general information with us so that you can have a much more informed conversation with your own attorney on your own team. Let's just get right into it. I mean, you're an attorney at Christ Enderle, and you specialize in a lot of different types of real estate transactions.
Yeah, real estate, that runs from purchase agreements, leases, anything really related to acquiring properties, and do a lot of bank work as well, and loan documents. That's always important to a real estate developer. Anyone buying real estate, they need to keep an eye on their loan documents as well. So that's the probably 80% of my time is related to real estate. I enjoy it. It's been doing it for 8 or 10 years at this point. So
8 or 10 years. Wow. So you've seen a lot of things.
Yes, many things. I started back 2006-07, I worked for a foreclosure firm. All we were doing were foreclosures. So maybe not the happiest thing to do, but it was necessary at that time. But that's where I kind of got my start, was banking work, doing foreclosures. So,
well, I think that's a great place to kind of begin the topics here. Let's talk about foreclosures. I mean, you started in 2006, 2007 doing foreclosures. I mean, you couldn't throw a rock without hitting a foreclosure at that point. What was that time like, and where are we now in that? I mean, can you still buy foreclosures?
Sure. Yeah, I think back in that time, I mean, the firm I worked for, they were doing, let's say, over 1,000 foreclosures a month. So, that was a great time, the leading edge. If you wanted to get into foreclosures, I think that time is kind of past at this point, that it kind of built up from 2006 through 2010. And once we got around 2012, foreclosures started to kind of kick down a little bit. Certainly there are still foreclosures out there to be had. But I think as they became more popular and there are so many good opportunities out there, investors really realized that and seized upon that. And, now I think you've got a lot of people watching for those foreclosures, whereas if you were back in 2007, 2008, you probably have a handful. So you've got greater opportunities back then versus now. But certainly, every week you or every month, depending on where you are, you can check the paper and see what's up for sale and do your diligence. And maybe there are opportunities there. Certainly, some of my clients are still out there watching those and buying foreclosures where when there are opportunities. But there's a lot of things you got to be careful about in that process as well.
What are some of those things you need to be careful of?
A lot of people don't understand necessarily the title, right? So when you buy a foreclosure, you think you may just go to the sale and buy the sheriff's deed, bid what you think the value is, outbid the bank that, in that circumstance. But we don't realize is that that's no guarantee of that you're getting a first priority position or that you're going to actually own the property later on. I certainly remember back when we were doing a lot of foreclosures, we would foreclose second mortgages. Now, some people might not think, why on earth would a bank foreclose a second mortgage? Well, unfortunately, when you see a lot of those deals out there, you might say, oh, the debt's only $25,000. This is a $400,000 property. I'm going to go after this and get this property. Well, it's a strategy. It may be a strategy position that the bank's using to push the second position to foreclosure to get the first position to pay them off. Well, if you go in as an investor, you think you got your great deal. You buy the second position. All of a sudden, you just took a position on the property subject to another lien. So you may have just thrown all your money out the window. So that's why you've got to do a title search, and you got to make sure that there are no other liens out there, because that's the only way that you could practically guarantee that you are going to actually own the property.
So let me make sure I understand what you're saying, because it sounded like you were saying that you had investors who were intentionally purchasing the second mortgage.
Well, I wouldn't say.
Or were they making a mistake?
Right.
And not realizing they were
exactly.
purchasing the second mortgage.
Unfortunately, I've had some instances where someone came into me and said, "Hey, look, I don't know what's going on. I bought this property at foreclosure sale, got a great deal, but then a week later, I got a notice from this other bank saying, hey, you owe me $40,000 or whatever it might be." Well, all of a sudden, that eats up all the equity. So it would be a mistake if you bought the second lien in most circumstances, because you would have to still pay off that first lien to own the property. So
obviously those were investors who came to you a little too late.
Correct.
Had they come to you in the beginning, you would have helped them realize or make sure that they were purchasing the first mortgage.
Exactly.
And getting themselves in the first position.
Right. And you think that it's easy, right? I mean, you may read about buying properties at foreclosure or whatever it might be. You show up, you bid, you own it, right? I mean, that's the simplistic view. Then all of a sudden you realize there are some technicalities that you got to be careful about. And, you're not always guaranteeing the person that owns the house or lives in the house. I mean, they could cause issues for you after the foreclosure, whether through it's an eviction or they could challenge the foreclosure. So it's not a risk-free proposition. But there are opportunities to be had. I think now there are a lot fewer opportunities than there were, 8 years ago. But
it seems like a lot fewer opportunities and a lot more people who are pursuing those opportunities.
Exactly. But I think it might come back, right? I mean, we're in one of those cycles, so it's good to know that you got the opportunity there to buy foreclosures. That's one avenue for an investor to go after. But I think we're still probably a couple years away. I mean, that paper used to be 50 pages of foreclosures. Now I think we're down to 5 or 10. So definitely much fewer people in default at this point. So
exactly. Well, what about bank-owned properties? Because there are still people out there who are pursuing bank-owned properties. What are you seeing from your perspective?
Yeah, so that's coming in after the foreclosure sale, after the bank has kind of gotten through the redemption period. So after the sale, there's 6 months usually. For the person who owns the house to redeem the property and save it.
And that's the redemption period.
That's the redemption period. So after the redemption comes up, then you're going to see the listing that says bank-owned property or something like that. Now, there is a small window, depending on who the bank is. You can actually buy, and this is kind of, a little more unique. Not many people do this, but you can actually buy their interest in the sheriff's deed. So some investors, if you know the bank, let's say it's a local bank, you know that they foreclosed, you know what they bid on at the sheriff's sale, you can actually come in during that redemption period and purchase their sheriff's deed. So that, it's a little bit less risky than maybe going in at the actual sheriff's sale itself. And you're also not waiting for it to be the, classified bank-owned property that you see listed. So there's an opportunity to get in during that redemption period and maybe get a little better deal, get the bank out. But, I say mostly with a local bank, it'd probably be pretty hard to accomplish something like that with a national bank, because there's some documentation, and frankly, they just don't want to go through the extra effort. They just want to get it to a real estate agent and get it sold. They don't want to sell their interest in their sheriff's deed. So, and
is that really a relationship kind of business, where if you are going to work with the bank, you need to have a relationship with the asset manager there?
Right, exactly. I would say when opportunities like that come up, you want to know the workout person, the person that's in their distressed asset group, to talk to them about what opportunities might be coming up. And there may be at local banks at this point, there may only be 1 or 2 people at the bank that deal with all the foreclosed properties. If you know that person, they can keep an eye out for you, and their job is to make money on these distressed properties to the extent they can. So if you know them and you can get these properties off the bank's books, that they'll talk to you and they'll work on that for you. So if you can bring the money and help them out, they will hopefully keep an ear out for you to maybe get you some deals as well. So
great. And it seems like with foreclosures, and this is my perception, tell me if I'm wrong, but just like with foreclosures, the idea of working with a bank to get bank-owned properties in that phase, there's fewer opportunities for that at this point. Right.
Much fewer opportunities. But I think we've got to look at, too, is remember that foreclosures, we're talking primarily residential properties, but there can be other opportunities on the commercial side as well, or vacant land, whatever it might be. Certainly back in 2008 to 2012, there were entire residential developments that were up for sale, up for liquidation. These lots that were going for $60,000, $70,000 a lot were going for all of a sudden $5,000 to $10,000 a lot. In hindsight, huge deals at the time, but not many people were getting into it. But if you did buy, you could buy practically a whole entire subdivision for $150,000. That probably was $1 million development. If you got in right at the right time, of course, there's a lot of risk involved in that. You're doing pretty well now as, housing is building up more. So.
Yeah, if you had the cash back then
exactly.
to make some of those purchases, because it really was kind of a cash. Those who had cash were the ones who walked away with the best deals.
Right.
Because if you went in asking to finance, well, that's a whole different story, and it takes a lot longer.
Yeah, the key on the bank side with negotiating with the banks are to understand that they want to get things off their books on a quarterly basis. So end of the quarters are important, end of the year is important. There may be a little more leverage to negotiate at that time of the year. It's a lot of strategy, and it's bringing cash, right? They don't want to finance. Generally, they're not going to want to finance you buying something from them. They want to get it off their books and move on. So you might be able to go to another bank and get financing, but cash is king, right?
Mm-hmm.
Always the case.
Yeah. Well, let's change gears here and talk about your relationship with the RPOA. And this podcast is sponsored by the Rental Property Owners Association, and you are a member of their team. So if I'm as a member of the RPOA, if I have a legal question, I can give you a call and say, "Hey, David, what do you say about this?" Or what should I do? Can you talk about that a little bit and bring it around in terms of the types of calls you get and what are the top 3 questions that people have when they call you?
Yeah, so right, exactly. If you come into the RPOA, they're great in the office. They can answer a lot of questions for you, but every once in a while there's the more difficult question or one that doesn't come up very often. So I'm part of that team that you may get a hold of me. They'll give you my number, and typically what that looks like is a maybe 5 to 15 minute conversation to try to sort out the question, get you an answer, and do the best I can to guide you in the right direction. Because what we often find is that when there is a legal question, we always like to think it's black and white. Very rarely is it black and white. And then of course, if they can't answer it in the office, it's not something they see very often. It's probably something that we've got to talk about and figure out. Okay, here's the pros and cons, or here's what direction the judge could go. A lot of them are, frankly, related to evictions, right? People don't necessarily. The court is made so you could conduct your own evictions if you want to, and many people do. So they don't hire an attorney, and they may have one eviction every 3 years or one every 10 years. So they know the tenant, so they feel comfortable going into court and trying to go through that eviction process. But I always say that evictions are deceptively simple. If you don't know all the risks and problems that could come up, it's easy to go through with the eviction and have confidence in it. But as soon as one of those problems arises, then you've got a judge saying, no, you can't do this, or I'm going to dismiss the case because you haven't followed this proper procedure or waited enough time between the initial eviction notice and filing the complaint, whatever it might be. So that's one of the most common question I get is certainly related to evictions. When can you evict someone? Can I rent to this person? Should I rent to this person? What happens with Section 8? Those types of things, and ultimately, one of the greatest concerns for people oftentimes is, non-payment of rent is the most common type of eviction to happen.
It's one of the most common reasons that would evict someone.
Exactly. Mm-hmm. But where a lot of the problems come up is when you're trying to evict someone for other reasons that are not non-payment of rent, just too many people in the house, or somebody who's not on the lease is living there, or they have a pet, or they're destroying the property, or whatever it might be. That's when it becomes a little more complicated, because it's not as straight and narrow when you get in the court to argue, hey, judge, they broke the door. What do I do? I want to evict them because of that. There's a lot deeper analysis that goes into that in terms of whether that's material enough to get an eviction. Is it repetitive? And did it actually happen? Who did it? Sometimes it's, the neighbor did it. It wasn't us, and it's not our fault. So it can be difficult to evict somebody in that circumstance. But evictions are kind of the main question that I get. The other question might be related to LLCs.
Well, I'll tell you what. Before you go into LLCs, since we're on the topic of evictions, let's kind of segue into the class that you teach on evictions. because you teach 2 classes or courses for the RPOA. One is on evictions, and then the other one is on
asset protection.
Thank you, asset
Yes.
protection. But let's stay with evictions since you've already begun that. Starting with, give me a story, or like what's one of the most bizarre or interesting eviction cases you've dealt with?
There are many bizarre, interesting evictions, right? There's always something you don't expect. The one I tell in my class, so it's the simplifying the eviction process, how to conduct evictions is kind of the topic of the class, and we talk about generally how to walk through a non-payment of rent situation, so you can go out and do that on your own. But the one story I tell is that an eviction, people sometimes don't think that the eviction is actually going to happen. So you get your court order, you get the order saying that you can have the eviction. You can get a court officer to go out there to actually physically remove everything. And you see movies or you see stories about everything on the curb. Mm-hmm. Well, that's actually physically what happens. So people don't believe that might actually happen to them. And particularly, let's say if it's a wealthy person, they might think that they're not going to do this. They're not going to move my 4,000 square foot house to the curb, are they? So we had an eviction. This one was actually after a foreclosure. We had an eviction where our client foreclosed on the property, got the eviction order, and albeit 10 days later, they're still there, and we send the court officer out, and we physically removed everything to the curb. And one of those items that
everything in the
house, 4,000 square foot house, everything to the curb. And of course I wasn't there, but I got a picture of here's the grand piano on the curb, So evictions are not. I mean, it's not humorous, but it's a difficult situation. Yeah. But it's important to you're the landlord. You have the right to move people out.
If you're renting to someone, they need to be paying you the rent.
Exactly.
If they don't pay the rent, you give them ample warning, and there's laws that are there in their favor.
Exactly.
So that they do have ample warning, but at some point, they have to pay or they have to go.
Right.
So the piano on the curb, I think is
you don't want your piano on the curb. I'm sure it was a matter of principle, right? But it's a difficult situation. But at the end of the day, you've got those rights, and sometimes landlords get a little bit frustrated, and oftentimes in the court processes, the judge decided this, or why'd they do this, or why did they get more time. The process is there for a reason. Tenants do have a lot of protections under Michigan law, but ultimately, you do have a right to get possession of your property back if they haven't paid. So it's sometimes frustrating that could be a 30 to 60 day process to do that when somebody's not paying rent, but ultimately you can get there. It's just you got to follow the rules and jump through a few hoops. So that's ultimately what the what the eviction class is about. The eviction class is teaching you about basically here's the reasons that you can evict somebody. So you've got the non-payment of rent, but then there's a half dozen other reasons that breach of the lease, for example, that you can evict someone from. So it's good to know under what circumstances you can evict someone, and then we'll walk through step by step from the point of default or point of non-payment of rent to the notice to the complaint. To going to court, what do you need to do when you get to court? How should you dress? How should you act? Do you check in? All those simple things, but for someone going through it the first time is somewhat uncomfortable. So, and then through the eviction order and actually evicting them. So it gives them through about an hour. We spend probably an hour or a little bit more even on that and answering questions related to evictions and situations that people have had. But at the end of the day, the goal is you walk out of the eviction class with a great understanding to conduct your own eviction if you have to do that, and avoid hiring that attorney, assuming that it's a simple process. Mm-hmm.
So is the takeaway from your class is that you can do the evictions yourself. You don't have to hire a lawyer to do the evictions, but it's good to learn how to do it properly, and have you teach them. That's a valuable thing.
Right. So the one caveat there is in some courts, if your property is owned by an entity, an LLC or a corporation or a partnership, you do need to have an attorney. It depends on the court. So just keep that in the back of your mind. But in a lot of courts, or if you own it individually, yeah, right. The idea is you can go through and do that process yourself. What I say is that, look, you could probably scrape through this without knowing a lot of these details. You might not need to know all these intricacies, but if you know all the intricacies, it's less likely you're going to make a mistake and have to start the process over, or have the judge, scold you for not doing X, Y, and Z, or, losing the case and having a lot of effort. Even if you're not spending a lot of money necessarily with hiring an attorney, there's still a lot of time and effort to go through the eviction process. So the idea is to minimize the opportunity for an error to occur so that you get through the process smoothly.
Yeah. So if you ever have to go through an eviction, it's good to have this information in advance and not find out by trial and error as you put your rental income in jeopardy.
Exactly. And the most important thing, I always say, the most important thing is to get possession. They may owe you money. There may be all these side disputes, but get possession. Deal with that later if there's a lot of disputes.
Get possession of your property.
Get possession of the property. Exactly. That's where you make your income from. That's the most important thing. And that's why it's also important to act quickly if somebody isn't paying, because you want to get them out as soon as possible or get them paid up. So possession is the key. And sometimes during the eviction process, you get lost on all the other side things and start fighting over things that maybe, are immaterial. Ultimately, you need to get somebody else in there renting the property. That's how you make your money.
So you teach the class on evictions. You dispense the information. How often do you actually help other? Are you enlisted as the attorney to help with evictions?
Sure. I think we're in court weekly on evictions, certainly. It's more common for us to represent someone who has multiple evictions. It's probably one of two things. It's someone who has apartment complex or multiple houses, or a property manager for multiple houses. So that they have a regular need for evictions. That's where our most common client probably. Or on the other complete opposite side is someone who really shouldn't, they're brand new landlord, have no idea what they're doing, and they're just lost in the process. So we'd help them through on that side as well. People that are in the middle that have been in property management or been a landlord for a while, oftentimes they might handle their evictions themselves, but once you get some volume, it always seems to make sense. You got to value your service, but do you want to pay somebody else to do the notices and the complaint, or do you want to sit at your office doing them yourself? I mean, that's ultimately what the question is. If you value paying somebody to outsource that, so to speak, and know that you're going to also have some legal expertise in doing that, that's kind of that's what our client will look like if we're doing a lot of evictions for them.
And what are the typical costs then of going through an eviction?
Yeah, I always say, in Michigan, you can collect up to $75 for an attorney fee. That's a little bit low in terms of, certainly some attorneys can probably do it for $75. Generally, we are in the $150 to $250 range for the legal fee, depending on what level of involvement we're on in terms, are we preparing the notice, are we preparing the complaint, or are we just going to the hearing?
So that includes going to the hearing.
Well, I would say correct. I would say kind of 250 is kind of the ballpark average number that you would probably find. But
so just for the legal part of it, for hiring an attorney, you're talking anywhere from 150 to 250,
right? And
of that, you can get 75 back in a judgment from the court.
Exactly. And then I usually say it's kind of could be a $400 or $500 endeavor, because you've got to pay a filing fee, you've got to pay fees to have the complaint served, plus the attorney fees. So ultimately, that's kind of the number that I think is reasonable to have in your head, is $400 to $500 when you've got an eviction.
Which is quite a bit.
Well, it is.
I mean, in some cases, that's almost a month's rent. Not to mention the rent you're not receiving during that period. Let's talk about what can help you avoid getting into that situation in the first place, which is screening.
Right. Communication with your tenant's important.
Communication, screening, and having a good lease. I mean, what are your recommendations about that?
Yeah, so we often run into, I think that's key, but regardless of all the legal language in your lease and everything else, it comes down to, from what I've always seen, it comes down to the relationship with the tenant. When we get to court, is it a situation where we're walking and we can have a reasonable conversation with them, or will the tenant not even look at us? If it's the latter, and the tenant won't even communicate with us, it's very likely that we might end up in a trial or some more convoluted, lengthy process to get them out. the most important things you should have in your lease, I mean, to have a valid lease, a legally valid lease, you don't really have to have much in your lease at all, except for a description of the property, name of the landlord, name of the tenant, what rent are they paying, and hopefully the term of the lease. But, the most important thing is, probably covering those ancillary items that you most likely will not evict somebody on, but you want to have protections. So, number of occupants, abiding by any rules, parking your car, how many cars can they have, disturbing other neighbors, that's important. I mean, you want to make sure that you have a community, if it's more than one unit, that the other tenants aren't being disturbed, because then you might lose another tenant over one bad tenant. So kind of all those other, the main terms can be covered in about 5 paragraphs. And there's the other 20 paragraphs are the ones that, you kind of probably wonder, why do these need to be here? Well, unfortunately, it's there to cover all the different circumstances that could arise, and a lot of them do. So that's where the most important. That's what your lease. If you have a lease that has 5 paragraphs, you probably need to reconsider that. Some people like to keep it simple, and that's okay as long as you understand that there may be some risk involved with keeping it simple. Then you might just have to rely on the non-payment issue. But
so where can you go to get a proper lease that's updated, that's relevant to Michigan? And that's going to kind of give you the protections you need.
Sure. So I think if you're a member of the RPOA lease really covers all those issues, and at least in the areas that I practice, that lease is widely recognized even by the judges. So they see the RPOA lease and they say, okay, they know exactly where to look for the late fees. They know where to look for, where's the monthly rent located, and when can you terminate the tenancy, that type of thing. So. It really has kind of become the standard lease. I mean, judges would expect, and even tenants probably, if they've been tenants multiple places, they probably run across this lease. So the RPOA lease, I think, is a great place to start, and they have a bunch of addendums that can address certain circumstances. And as far as I know, certainly there's. I think almost everything's been covered. Everything is covered. I mean, I've never really run into a situation, if you're using the right addendums and so forth, that, certainly every reason that you want to evict somebody is covered. That's a broad statement. That's a pretty dangerous statement to say, but it's pretty broad. So
what about, I'm curious about the changes in smoking, because it used to be you could say this is a non-smoking property. But now I've heard with the new medical marijuana laws that you may not be able to tell people they can't smoke. Well,
yeah, unfortunately, that's a great question. It's still a little bit in flux. Okay, so because of the federal law, we have now the medical marijuana law that maybe there's some concern that there could be discrimination or something like that if you tell someone that they can't rent your unit because they are going to be smoking medical marijuana or using medical marijuana. And there is some legislation that's in the works to try to clarify, hopefully, what rights landlords have with respect to this. I think the general rule right now is, until we see something different, is that you can use that non-smoking provision as one avenue to prohibit someone from using medical marijuana. And I say that cautiously because it's not clear right now. Mm-hmm. But if we ran into that situation, that would be one of the provisions in the lease that would be important to have, that we could use to say, look, we're evicting you. We're not evicting you because of medical marijuana. We're evicting you because you can't smoke and you're smoking. So it has nothing to do with the medical marijuana, or your right to use that. You have a right to smoke too, but I mean, outside of this property, you agreed to. It's not discrimination. So that'd be one provision to use, and then the other provision that you'd want to look for in your lease would be one that maybe says, violate federal law, because it technically is still a violation of federal law. So you could possibly use that. So you've got to be cautious, but we're hoping to have some clarity in the next 12 months, hopefully, on that issue, so we know clearly exactly what the rights landlords have with respect to that. It'll be just good to know one way or the other. So.
And do you work with the RPOA to help them update their leases as these things do get decided?
Exactly. Yeah, it's a constant updating process, because it seems like every year there's a little tweak in the law that changes. Last year it was there's an ability to send electronic notices to people instead of having to mail them. Frankly, that process is almost more complicated, but we had some discussion and made some modifications to allow that, and addendums when particular issues come up, addressing addendums so that that's an option. So that's something that someone can download, a member can download and use in connection with their lease. So it is a constant process, that's for sure.
The other, just to bring up one other issue that I've heard about is animals and pets. And even though you may prohibit dogs, let's say, a tenant could say, well, this dog I have for medical reasons or for psychological reasons. Can you talk about that?
Right. So what you're referring to are service animals, so to speak, and it doesn't necessarily have to be a certified service animal. But if there's a mental reason to have the animal or the dog or the pet or a doctor's note, even, it doesn't necessarily need certainly some are trained.
It's a low threshold.
Right. That's what I say. Exactly. It's a pretty low threshold. So you do have to be very careful about that. That's a question that I've had quite a few times. And yep, if you've got a tenant telling you that's the case, got to be careful. Go into eviction court on something like that. And, it's one of those situations you start to walk on thin ice. I mean, you might be okay, but a little more risk if you try to evict somebody for something like that.
Yeah.
So, yeah, I was going to say that would be a situation where you want to, if there's non-payment, you rely on the non-payment. You don't rely on paragraph 27 of your lease that says that, they can't have pets or something like that.
So the takeaway is that when it comes to evictions, the magic bullet is non-payment.
Exactly.
Anything else, you're entering into a gray area where you're really going to have to make sure you can prove what you need to in court.
That's exactly right. Yeah.
Okay. Why don't we talk about your other class, which is asset protection, because that's a really important issue for a lot of investors, for every investor.
Sure, asset protection. So it's protecting your assets, making sure that liabilities or exposures, kind of like we talked about with respect to evictions, you could get countersued, or you could have a slip and fall, or whatever it might be. And there's dozens and dozens of risks and liabilities for landlords that could come up. So in asset protection, we talk about generally how should we structure your business? Do we use an entity? Do we use a limited liability company? What are the pros and cons of that? And then we also touch upon insurance briefly. What types of insurances should you have? In addition to having this company protecting you, you also want insurance. Some people elect one or the other. That's usually not a good idea because there could be something that's not covered. If you just elect insurance, as if you run into an insurance issue before, there's a lot of exclusions from coverage. So you think you're covered until you have an issue, and then you realize that the 20 pages of exclusions, there's probably one that applies. And we've certainly had that one that's common. Vacant buildings. So you've got to be careful about that because many insurance policies have a vacant building exclusion. So if it's been vacant for 60 days and a fire happens, so you have a tenant that's moved out and it's gone for 60 days, you haven't re-rented it, fire happens, it's possible that you would have an exclusion from coverage there. So that's protecting you. You want to make sure you understand your insurance policy and how that might work. So that would be a loss to the property, obviously, but not.
I know, yeah, that's interesting because I know when I used to have single families out of state that I had State Farm insurance actually, and I would notify them if a tenant moved out and the property was going to be vacant for more than 30 days because of that exclusion.
The reason is because when it's vacant, the risk is higher. So the insurance company is taking that into account, and they may want to elect the opportunity to charge you more money.
Have you seen? Yeah, because they would charge me a little bit more just for that month or two that while we were finding a new tenant. Have you seen instances where insurance did not cover what the owner thought it would cover because their property was vacant at the time? Yes,
yeah. I had a significant loss a year, or one of my clients had a significant loss a year or two ago where it was vacant and it was over in excess of $1 million that wasn't being covered. The property was essentially a total loss because it was vacant. That was what they were relying on. Otherwise they would have had coverage. I mean, if they would have notified them, like you just said, it would have been as easy as hey, it's vacant. Charge us whatever you want us to charge us for the premium, and they didn't do that, and that clause applied, and it was kind of a direct loss. But insurance that's protecting against a casualty. But insurance can also, insurance also should be used to protect you against personal liability. And that's where
like slip and fall
or somebody, somebody becomes injured on your property or something happens on your property that could result in liability. And that's where you want to use a limited liability company, an LLC, to protect against. So that's kind of the
you want to use your insurance
and the LLC, just to make sure if the insurance doesn't cover it. Worst case scenario is the creditor or the person that's after you can only get to the LLC and they can't get to your personal assets. So, in the asset protection class, that devolves to a discussion about how many LLCs should I have? Should I have an LLC for each of my properties, because that would really silo out all of that exposure? Or should I?
Yeah. What do you typically say?
Yeah, I think that's always a case by case. You have to look at that, in your own personal life to determine how much risk are you able to take on, right? So that's one of the first questions.
Yeah. Well, let's step back a little bit, because I think that there's a lot of investors, especially those who are just now getting into purchasing their first rental property, who wonder, well, why do I need a LLC or a partnership or anything? I mean, why is it a good idea or not a good idea to hold a rental property in your personal name?
Right. So the main purpose of the LLC is it provides liability protection. All right. So that means essentially if someone sues the LLC owns one piece of real estate, but you own, you've got $1 million in your bank account individually, they can only get to that one piece of property that's titled to the LLC. So, that's the main reason that people
separates rental property. An LLC, limited liability corporation, separates your rental property from all of your other assets.
Exactly. So
if I held a property in my personal name and there was something that happened at that property that caused personal liability, how exposed am I if I hold it in my personal name?
Right. They can essentially get to everything that you have, except for possibly there's some protections in Michigan that would protect a house that's owned by husband and wife, your principal residence essentially. So, but everything else would be open for them to go after. Not a good situation.
Yeah, have you seen that type of scenario play out?
Oh, of course. Yeah, of course. And I always cringe a little bit when you get into some litigation and it's owned in your individual name and somebody does sue you for, I've had certainly suits in the six-figure range, even on just what we think is a simple landlord-tenant case. It could be, what it is, mold or lead paint or whatever it might be. And now all of a sudden the tenant says they have all these medical bills and here's a huge lawsuit back. You're just trying to evict me and get possession. But guess what? You owe me $100,000. We'd feel a lot better if that was against an LLC, because then at least we know, okay, our exposure is limited to this. Now, if it's in your individual name, all of a sudden we know, well, geez, your exposure is limited to really nothing. They could garnish your wages, get at all your bank accounts, get at your other properties. So it's really not I usually recommend, certainly if you have multiple properties, that, you should have them in LLC.
Right. And you've seen situations where people own property in their personal name and they've lost big, whether it be through money or assets, because of something that may have happened at their property.
Yeah, exactly.
So how strongly then do you recommend that people who own property in their personal name think about putting it into some sort of entity?
It's very important. If anything, it's just the peace of mind that you've got that protection out there. I mean, that's almost more important, so that, if you do have this significant potential exposure, I mean, litigation, particularly getting sued, is a stressful process. Even if you think you could win, there's a lot of legal fees involved. So if you have the LLC, you at least know the scope of your risk, right? The scope of what worst case scenario. If you've got your personal name involved in that, it raises that, the stress in that situation is much higher. So I don't really, it's so simple to form an LLC. I think
so. Is LLC the way to go? Because a lot of people are wondering, well, limited partnership or other types of entities. Do you recommend LLCs? Is that the best way to go?
I'd say for the vast majority, 95% 50% or higher, an LLC probably makes sense for them. There can be some unique circumstances for larger developments that maybe a limited partnership, might make sense. But LLCs generally are the way to go. They're simple, just a quick filing with the state. You can have multiple members, multiple owners, and that becomes a little bit more complex. You've got to have an agreement between all the owners if you've got more than one owner.
So more than one owner, you'd have to have an operating agreement.
Right.
It kind of explains the relationship and the equity split between everybody.
Exactly. And that's another area that's kind of a place where people run into problems is everyone thinks that you'll get along. Of course, you're getting into a business with someone, you're going to get along, but it's important at the beginning, if you are going to have multiple owners of the company, investors or whoever they might be, that you understand what happens if you don't get along in 2 years or 5 years, because that's the resolution is in court. And again, no one wins typically in court. And you have a lot of expenses involved in that, and it's a very lengthy process. So
even if I get together with my buddies and there's like 6 of us and we want to buy a house and flip it, you're saying we need an operating agreement for that?
That's probably a good idea. Although I don't know who your buddies are, but
we're really good friends.
I'm guessing, when all of a sudden you make $200,000 on that flip, one of your buddies might say, "Wait, wasn't the agreement that I get 60% of this?"
Or didn't I do all the work?
Right. Exactly.
I should get more money for it.
So yes, it is important to have that. In death, what happens? Death, disability, divorce. What if one of the members files bankruptcy? There's dozens of different scenarios that could crop up that you don't anticipate. And some of it's not something that's somebody's bringing upon themselves, like a divorce. But you have to have a way to value all of those interests and what happens in those circumstances, because you might not want to be a member in this business with the ex-wife necessarily.
Mm-hmm. So the operating agreement is something that the lawyers put together, which basically covers every type of scenario you can imagine. And what happens in those scenarios as far as the partnerships or the partners or members of that
members, right?
The members of that LLC are concerned.
Exactly.
Right.
Yeah.
Very important document.
It is.
If you have more than one investor.
Right. So it is something that people kind of skip over or don't worry about, because it's only a problem until it's a problem, So
and it will become a problem.
Of course, I see a lot of problems. I don't see not necessarily all the good times that people are having, but there's a reasonable chance that you're going to have to look at that document at some point during the business relationship to find out what happens. How do you buy somebody out? What's the formula that you agreed to? That's the most common situation. So you want to make sure you agree to that up front.
What are some of the mistakes you've seen? Again, I like stories. So what kind of mistakes have you seen in the operating agreement or in the structuring of an LLC?
Yeah, so I think I don't know if it's a mistake, but one of the tricks, let's say, one of the things that people don't realize is I alluded to it, is a bankruptcy or a divorce. So there's a provision in your operating agreement that you can put in that has essentially a liquidating event if there's a bankruptcy, let's say. So one of the members files bankruptcy, and typically during that bankruptcy, they might have to sell the interest, right? The bankruptcy trustee might have the ability to sell that interest. So what you want to do in your operating agreement in that circumstance, you don't want to open yourselves up to being an owner with some third party that you don't know that might come into the company. So what you have is a provision that basically really limits the value of the bankrupt member's interest. It might be a set dollar or how much they put into the company or whatever it might be, but it generally is not the market value. So what you want to do is make sure that provision's in there, because if not, you've got in a divorce, you've got two people that maybe shouldn't be members fighting over an interest in it, or you've got a bankruptcy trustee that is taking an interest in this company. So you want the ability for the other members in the company to buy out. If one of those events happen, you want to make sure you can buy them out at a discounted value. Mm-hmm. So it has to be a reasonable discounted value. It has to have some relation, but
it's better to define up front what that value is going to be determined upon, rather than after everything has gone to hell and everyone's arguing and fighting to try to figure out how you're going to value it.
Well, another area, I mean, you can really agree to anything in the operating agreement. So it might be get creative. It might be someone has been convicted of a felony. Well, you have a right to buy them out at a specific number if they're convicted of felony, or if they're negligent and if they're one of the operating managers, or they're actually doing something for you within the company, if they're negligent in their duties, or they take money from the company or something like that, you may want all these things to be triggering events, penalties, so to speak, so you can get someone out for a reduced number. You know, you can't do something bad, hurt the company, and then get the fair market value. Mm-hmm. You might want to have some clauses that would allow you to get them out for something less. So something to consider. Again, things that you don't think are going to come up, but they are important. So
great. So as far as asset protection in the class you teach, you need an LLC. 95% of the time, an LLC is probably what you need. Mm-hmm. You need insurance. And what else do you talk about in that class?
Well, the one thing that one other area we touch upon are estate planning and trusts. So there are some national organizations that use trusts to protect assets, but it's important to know in Michigan, generally a trust is an estate planning tool. It's not a way to protect your assets. So what we say is, if you can get to the asset through your trust, then a creditor can too. So most commonly, someone will have what's called a revocable trust. And if it's a revocable trust, that's usually used for estate planning. And it's revocable, which means that tomorrow, if you don't want it to be in the trust, you can get the property out of the trust. Well, in Michigan, under Michigan law, if I were to sue an individual, I also can get at what's in their revocable trust. So we do touch upon estate planning and how that relates, and really, frankly, how it doesn't relate for the most part to asset protection. Now, estate planning does somewhat relate to maybe how you hold title or who the member of the LLC is. You want to make sure that underlying a lot of these structures are what happens if someone were to pass away. So the estate planning and the operating agreement for the LLC kind of comes into play there to make sure that ultimately you've got a process in place. So if something like that were to happen, everybody knows what your intentions were. But otherwise, it's right. It's the LLC, it's the insurance, it's making sure that you've got the operating agreement in place, that of course you have to title your properties in the LLC. So you've got to deed the properties to the LLC. And then it's following formalities. You know, one of the things that can be a pitfall for someone is if you don't follow the formalities of the LLC. Well, what's the formalities mean? It means, are you signing your contracts on behalf of the company? So all of a sudden you did a good job. You formed the LLC, you put your property into the LLC, but if you didn't sign the purchase agreement or whatever it might be, or the contract for trash under the name of the company, all of a sudden you're back to being individually exposed. You know, I had a client that set up the LLC, had an LLC for their operating company, had an LLC for some real estate, and then all of a sudden signed a contract, a service contract with someone, but forgot to put his company's name. Well, you know, as it might happen, of course, at some point the business started to go upside down and they couldn't pay their bills. And, you know, he comes to me and says, "Oh, but I've got the LLC. I'm all set. We're just going to shut down the business and walk away, and we're good because everything's with the company. Where I'm protected. So I'm just going to individually walk away and leave my company behind, and creditors can, you know, do what they can with the remaining company assets." Well, of course, a lawsuit ensues, and you know, they sue him individually. So I said, "Well, let me see the contract." Well, of course, he signed the contract individually. So, you know, you've got to, when I talked about the formalities, it's really just making sure you've got a company bank account, that you're treating it as a separate entity, it's not commingled with your personal funds.
Yeah, you would have a separate bank account for your LLC.
Exactly.
And separate tax returns too, if you
well, right,
depending on whether it's a dual member or not.
Exactly. Usually you'll probably have some sort of schedule that you'll attach to your individual tax returns to show what happened within the company. But you've got to follow all those things, or you're not going to get that liability protection, or someone could challenge and say, "Look, this is a farce. You know, this isn't really a separate company. You shouldn't be entitled to all the protections that you otherwise would be." But the biggest pitfall is always to make sure that you sign on behalf of the company. I can't tell you how many times I see every year where someone's getting sued because the company's getting sued and them individually, usually, because they signed it in their individual name and forgot to say as member, as president, or whatever their role is. Certainly, attorneys like to look for things like that because, right, otherwise they may be stuck with a shell entity. So you really want the attorneys to look at things like this to try to find ways to get to you individually. So you've got to do the best you can to, cross the T's, dot the I's so that the attorneys can't get to you individually, and you've done everything right. So it's important, but that's what we go through. It's, we spend about 2 hours going through that, answering questions. And again, goal at the end of the day is to come away with, hopefully we've picked up a few things that, okay, we're going to come out of this and we're going to be a little better protected. We're going to go form that LLC. We're going to make sure, we're going to talk to our insurance agent, make sure we have the right insurances in place, understand what's covered, what's not covered. And by doing that, you're going to run a better business. It's going to be safer, less risky, and ultimately a better landlord, better investor at the end of the day.
Those both sound like fantastic classes.
Yeah, I think there's a lot to learn. And, there's many other classes that you can take part in too, but there's a lot of different things that you come in that class with some expectation of what you're going to learn, and you'll probably walk out with a completely different understanding, and hopefully it'll change the way you operate, or at least give you some ability to operate more efficiently, and think that the goal is to make sure you're in line with what everybody else is doing. You don't want to be left out. So that's kind of one of the purposes of those two classes, is to get everybody on the same page and make sure you have some standard protocol that you're consistently applying. So in your business.
Well, absolutely. And I think for a lot of rental property owners and real estate investors, especially those getting started, there's a lot of fear that you don't know what you don't know. And you can get in a lot of trouble with what you don't know. So I feel strongly that it's very important to have a good attorney on your team, someone that you can go to and say, look at this contract, look at this LOI or this insurance policy, tell me if I'm missing anything. So it's great to have someone like you working with the RPOA and dispensing this very valuable advice. And as we wrap it up, I'm just wondering if you have any parting advice that you want to leave people with.
Well, I think it's just not the attorney, but it's the accountant, it's your financial advisor, it's your insurance agent, and really it's the RPOA as well, right? You bring all those people together, and that's kind of your team. And your job is to be a landlord, you be an investor, make money with what you're doing. And it's going to cost you a little bit of money to have all those professionals involved. But if you have that team, and I think if a lot of people overlook is maybe, you got to be intentional about maybe meeting with them once a year or whatever it might be, even over lunch, just to touch base, what's going on with your business. Try to identify, the professional might not identify it themselves. So, try to identify what changes have occurred in your business that maybe you need a different insurance. Maybe something's changed with Michigan law with leases. Oh, gee, okay. Like we talked about the medical marijuana, understanding some of those changes as they happen. So it's important to have that team together. And if you have that team, I think ultimately it's going to cost you a little bit of money, but you'll make more money because you're going to be operating your business in a less risky way. You'll have less exposure and less problems that are going to cost you money to fix. So I think that's the main takeaway that particularly new landlords, investors should stop for a moment, look at who's involved, make sure all of those areas are covered, and then they're ready to take the next step and probably start leasing or selling properties.
Yeah, and I'll say this too. I consider myself to be somewhat cheap, and I know a lot of investors are very cheap, and they think, what? Why do I need someone? Why do I have to pay someone hundreds of dollars to do this for me? I'll just learn how to do it myself. And 10 times out of 10, that's the wrong attitude to take.
It costs more to fix. Usually,
first of all, it costs more to learn how to do it because then you have to take classes. You have to take the time to learn how to do it. Just hire someone who does it all the time. Yes, you're going to pay them. And yes, you're probably going to pay them more than you want to. But it's a more valuable use of your time to hire an expert and bring someone on your team to handle those things for you. And at the end of the day, you'll be able to sleep much more soundly because it's being done right by people who know how to do it right.
Right. I think that's great advice. And it is difficult, but I think it is important to keep that, value your own time, and make sure you've got the experts on your team to do it the right way from the beginning.
Fantastic. Well, David, thank you so much for taking the time to share all this great information with the listeners.
Yeah, thank you. I enjoyed it.
You've been listening to the Rental Property Owner and Real Estate Investor Podcast, brought to you by the Rental Property Owner Association. You can find out more at rpoaonline.org. If you enjoyed this podcast, please go to iTunes to subscribe, rate, and review.